Commission meeting for February 21st, 2012. First order of business, pledge allegiance, please.
Indivisible, with liberty for all.
Kate, could we have roll call, please?
Sure. Williams?
Here.
Shannon? Here. Knutson? Evans?
Here.
Bryson?
Here.
Kidd?
Here.
Dearborn?
Here. Okay, everybody's here. Introduction, I guess we have a new face tonight. Welcome aboard. Was it Sean Kidd? Is that what we go by?
Yeah. Sean Kidd.
Welcome aboard.
Thank you.
Like to tell us a little bit about yourself?
Sure. Originally from St. Augustine, Florida, for any history buffs out there, the oldest city in the United States. So, I'm an attorney. I've been an attorney here in Oregon about 3 years, and been an attorney in Florida for about 10 years. So, live here, obviously, in Lincoln City, and been here for about 3 years as well. I have 4 kids and lovely wife, so glad to be here.
Yep. Welcome aboard. Thank you very much. Look forward to your input. Any agenda changes or revisions?
None.
None whatsoever. Next is a request for approval of the minutes for the meeting of February 7th, 2012.
So moved.
Chairman, I move that we accept the minutes as presented to us.
Second.
All those in favor say aye.
Aye.
Opposed? Okay. Quick meeting so far. Final orders and resolutions. Just a minute here. Little script for this evening. The Commission is about to vote on final orders for Variance 2012-1 and Variance 2012-2. The applicant for these variances is Chris Saltvedt. Final order is a written record of the Commission's decision that followed its public hearing held on February 7th, 2012. There is a final order for each of the 2 variance requests. The Planning Commission's decision was for a denial of the variances. The final order reports the findings of the Commission, explaining how the decision relates to the evaluation criteria. It includes the vote of each member by name and briefly states the basis for any minority vote. The vote on the final order is not meant to be a second vote on the subject of the hearing. If the final order accurately reflects the finding of the majority and the decision, commissioners should approve the final order. Is there a motion for final order variance 2012-1, which would be final order 2012-02?
Mr. Chair, I move we approve final order 2012-02.
Okay.
We need to do them separately, I assume?
We do. We need to do them separately, please. Thank you.
In the motion.
Okay. Kate, roll call.
All right. I'm going to call your name, but then you'll probably say something. Kidd?
I'm going to recuse myself from this vote, considering I was not present at the last meeting and didn't hear testimony, so I'll recuse myself.
Okay. Williams?
Yes.
Bryson?
Yes.
Shannon?
Yes.
Evans?
Yes.
Dearborn?
Yes. Is there a motion to adopt final order for variance 2012-2, the final order number 2012-03?
Commission adopt final order 2012-.
A second?
I'll second it.
Okay. Kate, could we have roll call, please?
Sure. Shannon?
Yes.
Williams?
Yes.
Kidd?
Again, I'll recuse myself from this.
Bryson?
Yes.
Evans?
Yes.
Dearborn?
Yes. A notice of decision will be mailed to the applicant and to all others who participated in this hearing in person or in writing. This decision is appealable to the City Council. Okay.
Mr. Chair?
Yes, sir.
Just as a matter of form, I think you skipped item number 5, and even though there's no public here.
I'm sorry. I got ahead of myself.
Okay.
Okay, so public comments on non-agenda items and agenda items 7, 8, and 9. And we have no public to apologize to, but I still apologize. Got ahead of myself. Okay. Next, there are no public hearings scheduled. There is no old business scheduled. And next is new business, and it is for some Planning Commission training. And I guess we're going to hear from Joan on this evening. Yeah.
Okay. Thank you for giving me some time on your agenda. I try to do an annual training, and usually it's a fairly quick review. I know you also individually go to different training programs for planning commissioners. And from time to time, occasionally one of you will ask me a question that will give me an opportunity to do a little bit of review for the commission. My purpose in giving you the set of, I think, five different sets of materials was not to overwhelm you with things to read. If there's nothing on TV or you're otherwise, just have plenty of time on your hands, then you might want to look through it. But I think sometimes it's helpful to remember that even though most of the time you are operating under our city ordinances, because that's what you see most of the time when staff gives their report, the criteria that you're hearing, the standards that you're hearing are standards from our comprehensive plan, our code, or the planning and zoning ordinance. But the backdrop for your authority and for your sitting here tonight is really state law. And the procedures that the city has to follow are also outlined in state law. The benchmark or the standard that you need to reach when you make a decision for a quasi-judicial decision is provided in state law. And of course, appeals of those decisions are ultimately decided by the Board of Land Use Appeals. So we also look to their standard, their scope of review, as well as the Court of Appeals, which is the final arbiter, if there's judicial review of a LUBA decision. So that's the thread that's carried through everything staff does. When they send out notice of a hearing, it's not just because the city thought it was a great idea, but actually because the program that was set in motion by Senate Bill 100 and later amendments to the statute that were adopted decided and that basically in order to have due process, in order to have a fair hearing, there has to be notice that is going to reach the people who should have notice, and that's defined, and there should be an opportunity for a hearing. So those are the basic a public hearing where you can produce evidence and speak, and where anybody can come, not just people who receive notice, but any member of the public can attend. So those are sort of that's the broad world that we live in for the Planning Commission. My purpose tonight was to concentrate on the issues that I think come up most often for you, which are the issues of ex parte contact and a little bit of that, and conflict of interest I'd like to review. But I'm going to go through, just spend 2 or 3 minutes on the set of materials so that you know that these exist and you can go back and look at them, if you want to. And if there's anything else you want me to address tonight, I hope you will stop me in the middle of whatever I'm saying and ask me a question. I don't mind that. Don't wait till the end, because, I might just go on and on. No, my intent was to spend roughly 20 or 30 minutes, and then if there are more questions that I can answer tonight to do that, and if there are ones that you want me to come back at some later time, I can do that also. And if anytime you want a different course, just let me know. Does that sound okay?
Sounds good. Thank you.
Okay. So the first set of materials I wanted to briefly explain was the one that has an index, the selected statutes. On page 2, ORS 197.763 sets out the specific guidelines that I just talked about notice and hearing. And these are the statutory guidelines that we follow in our adopted procedures. So you can exceed this. You can send notice. This says you have to send notice of hearing to those who live within 100 feet. I believe that our code says we send notice to those who will live within 250 feet. So you can exceed these standards, but these are the minimum standards that cities and counties need to follow. I wanted to briefly go over the scope of review for LUBA. I'm moving to 197.835. And starting on page 5. I don't think I've ever raised this in a training. I don't think we've had an appeal to LUBA that has not been dismissed or otherwise settled since in the 7 years I've been here. Anything?
No,
I don't
since
think
I've
so.
been here, I don't think.
Normally, appeals have been decided at the Planning Commission, at the City Council level. A party might have appealed that decision, but they later either dismissed the appeal or it was just otherwise settled and then dismissed. Sometimes, somebody might appeal for a reason that has nothing to do with the city. The city is often not the interested party. It's the property owner that's the interested party. So they have to decide whether or not they want to carry that appeal forward. But my purpose in talking about this tonight was to alert you to the things that sometimes I do. I feel like it's just a sort of a traffic cop role where I might ask the Planning Commission to do something at the end of your discussion or at the end of your decision making, and this is where it comes from. I'm looking at 835 sub 4 that says a petitioner may raise new issues to the board if A, the local government failed to list the applicable criteria for a decision. So if we forget to list a standard and it should have been listed, then you can raise issues about that for the very first time. Even if there were 2 public hearings at Lincoln City, you can raise that for the first time at LUBA. Everybody would want to avoid that, so we concentrate on having those standards in place. It goes on to say the board can refuse to allow new issues to be raised if it finds that the issue could have been raised. Well, that just provides for a lot of back and forth discussion. So the sub B says, or the local government made a land use decision or limited land use decision which is different from the proposal described in the notice to such a degree that the notice basically did not describe your final action. In other words, if the public can't tell from the notice they got that instead of approving a 12-unit subdivision, you were going to approve a 112-unit subdivision, to make a gross example, then somebody could raise new issues about that because the notice did not adequately describe what your action was going to be. Section 5 says the board shall reverse or remand if your decision does not comply with the goals or the acknowledged comprehensive plan. It will reverse or remand an amendment to a land use regulation, I'm on sub 7, or the adoption of a new land use regulation if it's not in compliance with our comprehensive plan or the comp plan does not contain specific policies which give a basis for that regulation. And that's when you adopt a new ordinance, when you revise an existing ordinance. Let's see. It goes on in subsection 9. It can reverse or remand if the board finds that the city exceeded its jurisdiction, failed to follow the procedures in a manner that prejudiced the substantial rights of the petitioner, made a decision not supported by substantial evidence in the whole record, improperly construed the law, made an unconstitutional decision, and that's pretty much the end of that long list. But those are the 5 critical ones, A, B, C, D, and E. Exceeded its jurisdiction means that for some reason you made a land use decision, but you actually weren't authorized to make that decision. In other words, maybe we had no ordinance standards for it, so there was no authority for you to do that. Failed to follow the procedures. The critical part here is you might do something that's not actually laid out in your procedures, or you might have forgotten a step of a procedure. I think the board and the cases of the board pretty much detail that not every mistake is going to be critical. It's critical if for some reason the person who appeals that decision was not able to do something, and that's where that injury to that prejudice to their substantial rights. Mostly it's because something happened and therefore they were not able to testify, or were not aware maybe that an issue was a part of the application, or somebody was cut off from testifying about something that was critical to their application or to their point of view. You know, I'm just sort of summarizing there, but not every procedural mistake is going to be a reason for LUBA to remand or reverse a decision. If you improperly construe the law, well, that happens sometimes. The critical part of deciding whether there's substantial evidence in the whole record, and that standard of review is what I think of as the reasonable person standard, which is probably exhausted by definition, but the board will not question your decision for being right or wrong. In other words, if you could have made a multiple number of decisions and any one of them could have been approvable, then the board would approve your decision. But if it goes so far as if somebody reviewing the record that they had, reviewing the whole record, not just the parts you like the most or dislike the most, but the whole record, could somebody have made the decision you made? If the answer is yes, even if they disagreed with your decision, then your decision stands. And that has nothing to do with whether there was, you improperly construed the law or there was something that happened to be unconstitutional. Those are different standards. But that substantial evidence review is actually not a really, really high standard. But it does mean that you have to put that thing on the record that we call findings, meaning I'm making this decision and I think that the application meets the criteria because. And then the staff report usually refers to the facts that are being presented, the information that they have, which shows how the standard is met. If we don't make those findings, that's usually the basis for LUBA to remand a decision. If they can't understand how the city made a decision, or if the decision, sometimes it's a conclusionary decision. This meets all applicable criteria. Well, but somebody raised the issue that says it didn't meet 3 out of the 5 and presented evidence about why it didn't meet that, and the board can't tell what the city relied on, then it's going to send it back and say, articulate it. We're not saying you made the wrong decision, but we don't know how you got there. So give us that information. Now, if the board can figure it out from the record, they won't send it back. They'll make their own determination. And they have the authority to do that. The last thing that LUBA has authority to do is to uphold or not the city's interpretation of its own ordinance. And this has been the subject of a lot of litigation over the last 10 years. The standard used to be automatic deference to the city's interpretation. Now, I think the court has clarified, well, we defer to the city's interpretation of its own ordinance, because they're the ones they adopted it. The City Council adopted it. The City Council is the one to make the interpretation in the first place. But only insofar as that interpretation is consistent with its ordinance's comprehensive plan, and in some cases with the state goals. So you can't adopt an interpretation that says we allow some residential housing in a commercial zone if in fact that flatly contradicts what your ordinance says, just to give a simple example. I mean, that wouldn't fly. But if it's an interpretation that says we think that there's a list of uses in the zone and it allows for the Planning Commission to interpret that a use is similar to that list of uses, unless, you know, if the determination that an ice cream stand is similar to a coffee shop, coffee kiosk, then your interpretation will stand. So I don't know if that's a good example. I make these up on the fly, so you have to let me know if that's just not going to work for you. But on page 8, I've included the statutes that exist in state law to create the Planning Commission. 227.160 starts the group of statutes that discuss approval criteria, how development is defined, defining permits, and these are all apply specifically to cities. Finally, on page 14, 227.178 is a statute that staff and I constantly have in mind, and I'm constantly emailing Kate asking her, so when was the date this application was deemed complete? Because this is the 120-day statute. It basically says you have to make decisions on quasi-judicial applications within 120 days from the day the application was deemed complete. Now, that sounds like a lot of time, 4 months, but things happen, and that total time frame has to allow for time to appeal your decision to the City Council, which means we have to give public notice of that hearing, and then there has to be another hearing in front of the City Council. We've revised the code in the last couple of years. Not every decision that you make is appealable to City Council. That was not formerly the case. And if we fail to do that, somebody can file what's called a writ of mandamus, can go to circuit court, and can ask the court to issue the permit that they applied for. We try to avoid that happening. Anything you want to add on state law? No? Any questions on that section? See, I said 2 or 3 minutes, and I think I took longer than that. Right.
Joan, could you go back and explain what you were trying to outline? Page 8. It was 27.010.
227.0. Now, page 8 is creating the Planning Commission. 020. I think that's the state authority to create a Planning Commission that applies specifically to cities. There are also requirements in ORS 195 that also require the city to create a Planning Commission. There's a long list of powers and duties at 227.090, and I think some of them might surprise you. If you look at your planning function, the Planning Commission function is a recommendation function to the City Council, laying out and extending public thoroughfares, relief of traffic, betterment of housing and sanitation, establishing districts to limit use, height, area, bulk, and other characteristics of buildings and structures related to land. Solar control, solar access, and protection and assurance of access to wind for potential future electrical generation. Recommendations about parks, beautification of the city, vacant lots, future growth and development, public utilities, telecommunication. You can also, you cover making recommendations about regulation of industrial and economic needs, industrial pursuits, industrial advantages and opportunities of the city, encourage industrial settlement, make economic surveys, study needs of industries, basically do anything appropriate within those categories. So that's a long list of planning functions that are quite different from your quasi-judicial function. Sort of I think of those as the sort of master planning role. Is that what you were trying to go over?
I just saw that, and I was correlate where you were at with it, that you brought up the powers and duties of the commission, and I'm not there yet, but take that, because it's a lot more extensive than I would have anticipated.
I think of your duties as really including three major functions. The quasi-judicial function is where you're really sort of in the role of a judge, and you're deciding a specific application that somebody brings to you. I want to do this with my property. I'm making an application for that permit under your zoning ordinance. Can I do that? And you make those decisions. Those are strictly construed in terms of the procedures we follow, the 120-day timeline, and that's where conflict of interest, ex parte contact, and those issues, I think, can be front and central. The legislative process is really what I think of as your other two roles. One is you are, last year specifically, you adopted a lot of ordinance amendments. In your legislative role, there's no time frame. You don't have to take action. You can take no action. You can make no recommendation to City Council. You can say we don't have a recommendation. Or you can say we'd like something different than what we've seen. Or we want to have another public hearing on it because we don't think we're really getting ideas about this. So you have wide flexibility in your legislative role. Conflict of interest can enter into your legislative role, but it's more unusual. If the legislation concerns a specific industry and you are involved in that specific industry, then we can talk about that. But it's on a specific individual case-by-case basis, and it's happened very seldom that I can think of with the Planning Commission. And I think the third role is sort of a wider planning role of looking at what are the needs of the city, what should we be looking at that we're not doing, and staff generally brings ideas to you of things that it's thinking about. It may involve doing some kind of, what do you call them, charrettes, or some kind of public outreach. How does the city want to grow or change in the next X number of years? I think of that as Richard and Deborah's role, to present ideas to you, and then there's sort of some back and forth. So those are the three major areas. And again, that's a legislative, I think of that as a legislative function, not a quasi-judicial function.
Excuse me, Joan?
Yeah.
$7.090.
27-0. With that mean?
I think that's a crossover to the city's ability to plan for
Urban growth?
urban growth. There's something specific, though, that's within the 6-mile area, and I can't remember what it is, and I was just looking at it last week. Now it's going to drive me crazy. No, I'll bring it back, because it comes up again in the subdivision ordinance. I'm pretty sure there's a state law that has to do with...
And this almost looks like lunatic authority.
No, I think it's if there's a subdivision within 6 miles of the city, that the city has to receive notice from the county of that subdivision.
Incorporated.
It's something about there's a zone that has nothing to do with the urban growth boundary that was laid down in other statutes. That's my guess. But that's a really good question. And, you know, the people who are writing statutes now don't use the word thereof very much. So I bet I could find out if I went back and did a little research what the intent was.
Would that be similar to that subdivision that was in Rhodes End a year or so ago that the county was, we talked about it here, the county was approving it, but they were just assuming that we might be annexing that particular subdivision into the city at some point. They wanted questions or input or recommendations, or forget exactly.
I think anything in the urban growth boundary, even though we don't have an agreement with the county, I think they notify the city. Am I correct? You know, that the county notifies the city of any application they have in the urban growth boundary. Okay. Good question. Any other questions on the state law? Okay. Oh, I'm sorry. There's one last state law that I thought I should at least mention. It's on page 21. It's ORS 227.500. And this follows a federal law which has a terrible acronym that we refer to as RLUIPA, but it's basically the Religious Land Use and Institutionalized Persons Act, I think. The federal law. This is the state reflection of that federal law that basically says you're not going to discriminate, a planning jurisdiction is not going to discriminate against an institution because it's a religious institution. So I think the way this, I'm trying to think of issues that have come up with religious institutions, as far as I know, have been the same issues in a large part that we've had with other kinds of institutions. They're parking. You know, what is the available parking that's, or what is going to be the required parking, and is that available? I know that we had one instance where I think there was an issue of sound coming from the building during services, and the question was whether that was something that our zoning would deal with. And I think the answer to that was no. We do not have we have an enforcement level for construction noise, but I don't think we have a specific standard that says you can't, you know, make sound in a building that exceeds a specific level, as far as I know. So try to have like uses next to like uses, but you can see the potential for conflict when, for example, an office building is then used by a religious institution for services, and there's potentially, you know, what do you call it, amplified sound. But again, from what I've seen, is we've been able to accommodate that with conditions that require those uses to occur at non-office hours, or the person with the application is willing to commit to that so that there are no conflicts within the building. Yeah.
Has there been a process in place, or that's been used in the past, to involve the Planning Commission in that item number 3 that you described, the wider planning role? Impression, correct me if I'm wrong, that I got was that we would generally receive from staff their recommendations as to what needs to be changed and what needs to go on. Is there the reciprocal ability, or is there a process by which the Planning Commission engage in that, make recommendations as far as certain, say, something that maybe group through a study session would decide that this is a good idea happen, as opposed to being the recipients
Absolutely.
having a two-way street.
Sure. As far as I know, usually the staff memos are hoping to, people who draft those are hoping to get a response for the commission, you know, of these three things are great, we'd like to pursue those and develop some information on that. These other two we're not so interested in, and by the way, there's one that's not on your list, and absolutely.
Even suggesting number 4, it's not on the list.
Right, right. It's not on the list, and here's something
Can we begin to think about?
I know you, well, I didn't know whether you were referring to number 3 having to do with schools, and we don't know, the schools, I think, were actually not authorized, yeah.
I wasn't
Okay.
trying to find out if there was two-way process
Yes.
on the legislative or wider planning role, opposed to being always in a quasi-judicial function.
I think in the last year you've been more in your legislative function than your quasi-judicial role. As always, when development is slowed down, that's an opportunity to do more planning, do more master planning. That master planning is not without a cost. You know, normally the city is hiring consultants. We can't do sometimes the specific studies that we need to do in-house. But lots of times we can develop information in-house. So I think staff...
I would say that our lists, for instance, last time Richard ran through a list of things that we thought we should work on this spring. And typically those are because we've had requests to make changes in ordinances, or we have noticed problems. For the one with the projections into the required yard, for instance, is something that's come up several times in various requests, so maybe it's time to look at the ordinance. But since I've been here, 3 years now, I don't think we've done sort of a brainstorming or that sort of thing where we're talking about I haven't heard much from the commission in terms of what you'd like to take on or as new projects. And if you're interested in having that discussion, we certainly can. We have a fairly old comprehensive plan, and we talk occasionally about jumping into that and bringing it up to date in terms of demographic information, as well as thoughts on what we want to try to accomplish in the community. A more proactive approach is maybe what you're talking about. And if you're interested in doing something like that, we'd like to hear your ideas and for activities for the commissioners, as well as specific topics.
And not just directing that to me, but on the commission.
Of course, yes.
Moving to the city code.
Nodding with agreement with that idea.
Okay. I've given you a copy of Chapter 2.08, which is the municipal code establishing the Planning Commission. In the last couple years, we've had some instances where I know people, through no fault of their own, but may have jeopardized their qualification for appointment, and that's the single thing people can do is to move. If you move out of the city, we do need to know that. It may seem obvious, but sometimes we don't know that. And the other thing is, you're limited, the commission is limited that only 2 of you can be involved in real estate. for profit. And another two of you can't be involved in the same kind of profession, so you see how tricky it is to appoint people. I think that's it. Everything else is pretty self-explanatory. I've also copied for you 17.76, administrative provisions. That section of the zoning ordinance lays out your quasi-judicial hearing procedures and the notice procedures, everything you need to know about the process. And Chapter 1788 is pretty much the legislative process. If the staff is making a recommendation, or if you decide on your own that you want to amend an ordinance or change a map, then that is the process that we go through. One change that I've recommended to Richard is actually on 1788-065. That's our notice to DLCD. Anytime you are going to discuss, or we're going to propose a draft ordinance amendment, we have to give notice to DLCD 45 days before your first hearing, the initial hearing. That's recently been amended by the Oregon legislature, so that time frame has been reduced, which will make things easier for us. I think it's still 30 days, but there's also an emergency provision, which has actually always existed. But there's a big difference between 30 and 45 days in terms of our time frame for getting something adopted, especially when it's urgent, when the Planning Commission and City Council are all in agreement, this is a change we want to make. This will help speed that up a little bit. And I don't intend to go over those unless you have any questions. On page 5 of Chapter 17.76, these are the administrative provisions. 1776-030 is out the standard of review and is the standard you need to follow. The goal is to have an impartial review as free from potential conflicts of interest and ex parte contact as is reasonably possible. No member of a hearing body shall participate in a discussion of the proposal or vote when any of the following conditions exist. Subsection A sets out conflict of interest. It's a financial conflict of interest, and that sounds like an actual conflict of interest. It's a little bit different than the language that we have in state law in the government ethics law, ORS Chapter 244, because that specifically defines conflict of interest and potential conflict of interest, and I'll go over that when we look at the Luba case. Subsection 3, before I move on, your role, if you have a conflict of interest, is to declare your conflict of interest. If you have a potential conflict of interest, in other words, you don't have an actual conflict, you don't know for sure, it's just the possibility exists, so it's potential. Your role, again, is to put it on the record. What that does in a quasi-judicial hearing is that it opens up the opportunity for somebody in the audience, the proponent of the application or anybody else, to ask you questions about that. You don't need to do it more than once. If it's a potential conflict, then we simply move on. If the hearing is continued or there are multiple hearings, you don't have to repeatedly do that. You only have to announce it at the first hearing, and you can still participate. If it's an actual conflict of interest, you can't participate, and that's always been very clear.
Joan, I have a question, and it's language, because this is really, it's in my opinion, but 030, the quasi-judicial public procedures, and Section 1, it goes in there, potential conflicts of interest and expatriates contact, reasonable.
Ex parte contact?
Yeah, ex parte. What is ex parte?
Okay. I'm sorry. Tell me exactly where you're reading. Subsection 3?
.76.030, quasi-judicial public hearing
Right.
procedures and requirements. A1.
Oh, okay, what I just read, okay, ex parte. What, ex parte, what I think of that as meaning is basically, I think of it as meaning out of the room. So, for instance, you had a discussion with someone about somebody's subdivision application, and that your discussion was not with, was not just a casual couple of words about it, but somebody came up to you and said, I want to discuss Mr. Jones's subdivision application, that I know you're a planning commissioner, and I live right next to that property, and I'm really upset about the application. I want to talk to you about it. Before you have a chance to say, no, don't tell me anything, they launch into a discussion. That's okay. You don't need to be rude. If you can avoid it, that's always my recommendation. But your obligation when you come in the room, when Mr. Jones's application is now ready for a hearing, is to say, before we start the hearing, I want to declare an ex parte contact. What that means is I need to tell people here about a discussion I had outside this room, because it may or may not affect, it probably won't affect your ability to make a decision, but what that does is it provides an opportunity for somebody to ask you questions about it. That's, and it's our effort to make a fair playing field for everybody. So it would be the equivalent if you were the plaintiff or defendant in a case in court, you have your whole jury trial, and then somebody from the jury goes into the judge's chambers and wants to talk with them before they decide a verdict. We don't allow that. We don't allow that contact to happen. We don't allow the plaintiff or the defendant probably to go in. The attorneys can go in and talk with the judge, but we don't allow the plaintiff and the defendant to do that, or other parties. Somebody wants to have lunch with the judge and say, Your Honor, I know you're sitting on this case, and do you know that, Mrs. Jones is really a terrible person and probably did X, Y, Z. We don't have that in our culture. So I'm not aware of a case where there was remand or reversal. In other words, where LUBA or the court found that the playing field was so tilted against a party because of ex parte contact. And I guess what that means is you would have to have the single individual who failed to announce the ex parte contact, or for some reason the chair forgot to ask, okay, this is the opportunity for anybody to ask us about this, so affected the outcome that, but for that ex parte contact, in other words, it would have been a different decision.
Thank you.
It's rare to get there.
If you have these eager planning commissioners who want to be really prepared when they come in for the hearing,
Good question.
what are they to do and what should they avoid doing?
I would ask you to avoid doing your own research, with one exception. I've always thought it was okay to do a drive-by. Half the time you're driving by it anyway. It's a small city. You happen to say, oh, 5th Street, I know that piece of land. I'm going to drive by it and see, just take a quick look. All you have to do is say, here's my information that I got from outside this room, because, all the materials we give you are all public. Everybody has them. But we don't have your set of eyes, and we don't know that when you looked at the property, you thought, wow, that's really a steep slope. They're going to build that there? How are they going to do that construction? And then you go back and you look at the application and the plans maybe a little bit differently. I still don't think there's anything wrong with that. In fact, I think it's very helpful for you to understand the application. The important thing is to tell us that at the beginning, I just want to put on the record that I drove by this property, and this is the question that I had. Now, lots of times those questions are directed at Richard or Deborah, but really they should be directed, what staff will probably say is that, well, that's probably a question for the applicant. What's good about that is the applicant now knows, number one, you're pretty well acquainted with this application, and number two, you have a specific question. Now the applicant has the opportunity, when they come up to testify, to answer your question, or to say, which has happened before, you were looking at the neighboring property. You thought you had the right piece of property, you didn't. I'm not saying you or any individual person. So I think of it as a good thing, and I'm limiting my answer only to looking at the property so you can better understand the application.
Oh, don't get out and talk to the neighbors.
Please don't talk to the neighbors.
Yeah.
Please don't go on Google. Please don't start researching how they're going to put those pilings in there, and somebody whose building didn't work that way. I think those are all good questions. There's not, it's not going to be, there's never a bad question in this area. Don't get your own information. The reason why is you're going to have to bring that information in, and we're going to have to include that in the public record. The other concern I have about it is I think there can be some unwitting bias. It's really hard to kind of we're not asking you to put blinders on and pretend you don't live and get information just by reading the paper and talking with people. But if you can avoid getting into a conversation about Mr. Jones's application, that's a really good thing. I've also recommended people to say, if it's a specific application, I really can't talk about it, but please come to the public hearing, and if you have questions or want to say something, that's the place to put your concerns on the record. So invite people to come.
Yeah. As far as visiting the property, actually, I encourage it. I think it's a really good idea, so you get familiarity with it. But as pointed out, if Mr. Jones happens to be there, you shouldn't stop and talk to him about his application, or stop and talk to the neighbors, whether they think it's a good idea or not. And it's almost inevitable you'll be at a party or something, and someone will come up and say, I heard about this. What do you think? And then as Joan says, you basically just have to dodge it. And if you end up in a conversation, you fix it by coming in and disclosing the conversation, the substance of the conversation. You're not disqualified because you had the conversation, but you need to disclose it. That fixes it.
Unfortunately, some of the disclosures that I've had have happened in the course of the hearing rather than at the start of the hearing. Only when everything has already been put on the record, not with this planning commission, with another planning commission. And then a planning commissioner spoke up and said, I just have this question. I had a long discussion with the property owner when I went out to look at the site. This is the end of a 4-hour hearing. You kind of like, okay, we need a little time out. You had a conversation? When did that conversation? So we have to backtrack. When did the conversation occur? What did you discuss? It was just the eager planning commissioner thought he was doing the right thing. It would have been really helpful to know that in advance. And if ever it does happen, you don't realize until after the fact, but it's before the hearing, just give Richard a call or give me a call, and we'll just probably remind you. Just remember, all you need to do is to give us that information at the beginning of the hearing so people can ask questions. We make sure all that information's on the record.
If I can add a little bit also, you're allowed to talk to us, not ex parte.
Yeah.
Let me just continue that thought a moment. Can we talk to one another? If so, many of us could talk in the room.
It depends. If it is a quasi-judicial matter, I'd say no. I would not do that. If it's legislative, I think your role is a little bit different. You want to get information from your friends. We're considering a change in the height limitation from 45 feet to 55 feet. I'm sure a lot of people will want to talk with you about that. And that will be a helpful thing to come in and say, 20 people stopped me on the street, and they all think this is a terrible idea.
Let me give you a specific example. What if 3 of us are from the planning commission are sitting at coffee, and a fourth member of the commission comes in and we start talking about something that's on our plates.
Oh, well, then you have an unnoticed meeting because you have a quorum. So if you're talking about, I'm sorry, I don't even know, the last football game that just happened, or something else, or you're grousing about what some other county or city is doing, I think that's fine. But then if suddenly the discussion is, well, we're going to adopt the same kind of ordinance, ka-ching. So I'd say, unless it's a party or a clear social engagement where I think our ethics law recognizes that you have the right to do that, you just don't discuss planning commission business. So that gets me to, I wasn't going to bring it up, but email. If you send an email to everybody on the commission, I think you can send a letter to everybody on the commission. But if then all of the commissioners individually start responding to all of the other commissioners, now you have a discussion, and once again, you probably have something that will get people very exercised and would get us exercised. Sometimes we send out announcements, and if I'm sending the announcement, I specifically ask you not to reply, and if you have a question about it, to give me a phone call. And the reason why is because people sometimes forget and they hit reply all, and I'm not trying usually to start a discussion. Anything you guys want to say about that? Oh, I did. I made up the 55 feet. That's not going to happen. So, sorry about that. Didn't mean to give you a heart attack over there. All right. I wanted to turn to the very short excerpt, well, short, it's 4 pages, from Rosenzweig versus the City of McMinnville and McMinnville Habitat for Humanity. This was a LUBA decision that was decided just at the end of the year. And I think they knew that I was going to have to do a training on conflict of interest, bias, and ex parte contact. So they included all 3 issues in this decision. I cut out the substantive part of the decision, which I was not interested in for our training tonight. But just to let you know, you can find these opinions by going to the Oregon.gov, going to the Board of Land Use Appeals, the state agency, clicking on their website, and then you can find their recent decisions. I think they list them by date. So you can go back to December's decisions, and if you want to read the whole one, or we can provide, I can send you a link to it. So let me know if you want that. This is one that we can discuss at your next meeting if you haven't had time to read it. It, I think, is a favorable decision because it examines each one of the issues that was brought up and raised, and basically found that the Planning Commission had done the correct thing, as far as I remember. But I think it's a very good discussion about those 3 items, the conflict of interest, bias, and ex parte contact. So I can go through them if you want, or can. I've spent almost 45. So.
It's up to everybody else. I'm fine. We're on the subject.
Okay. All right. On page 1, they set out LUBA's in the 6th assignment of error. LUBA states that they can reverse or remand a quasi-judicial land use decision due to ex parte contacts or bias resulting from ex parte contacts if the member of a decision-making body that has the contact fails to make the disclosure required and provide the opportunity for rebuttal. So what these petitioners argue is that they were not, that the decision should be reversed or remanded because one of the city councilors engaged in an ex parte contact and they were denied an opportunity to rebut that. And they also said that the Habitat Board, the person who was a Habitat Board member, former Habitat Board member, had a conflict of interest and was biased in favor of Habitat. And I'm not going to address the false swearing issue because it's basically out of LUBA's jurisdiction anyway. That's a criminal issue, so they didn't have authority for that. On page 2, there's a discussion, well, I guess it's important to know that there was 3 city councilors, after the public hearing, 3 city councilors voted to deny the appeal, and the councilor in question voted with that group, and then 3 other city councilors voted to approve it, and the mayor voted to break the tie. So you can see this is a case where one vote might have been extremely important, and that was their opening, I think, to bring this appeal. At the meeting, the mayor had noted that the councilor did not attend the public hearing and asked the councilor to affirm she had listened to the recording and had reviewed the material, and she said she had reviewed it all. And then the mayor asked if councilors wanted to make any ex parte contact disclosures. And I think the conversation here is very helpful, because the mayor was very specific after the councilor said, yeah, I want to let everybody know that I introduced myself to the new executive director of Habitat for Humanity. Question, did anything come up about this application? Just in passing, it might have come up. Then he asked the other counselors whether they had anything to say, and another counselor said, well, I got an email, and because it was past the date, I didn't read it, but I forwarded it to the city secretary. And again, it's not really an ex parte contact, but he's just saying, I got this email, I didn't read it, it was about this application. Same thing, another counselor said, yeah, I got the same email, I also just deleted it. I'm not going to comment on that. If you ever get a questionable email, it's about an application, I suggest you forward it to Kate. Don't open it, don't read it. If you know in advance. If you don't know in advance, you still can forward it to Kate. And then the mayor said, okay, anybody else? Okay. Anytime we have an ex parte contact, what I'm going to do is I'm going to reopen the public hearing, but I'm reopening it solely for the purpose of permitting rebuttal on the substance of any communication that Councilor Menke had, and then also with the 2 councilors who did not read the memo. Does anyone wish to rebut any of the communications? And then there's a 4-second pause. And then he said, okay, now I'll open the public hearings. Again, does anyone wish to rebut any of the testimony that was received or heard by the council? If not, I'm going to close the public hearing. So he opened the public hearing, reopened the public hearing just to allow that rebuttal to take place for the ex parte contact. Silence. That's what the chair does. So even if you're in the middle of the hearing and I have to do a timeout, we're going to pause here because we've just had a disclosure of an ex parte contact. Again, it's not fatal, and there's nothing wrong with it. You've done nothing wrong other than the timing is in the middle of the hearing or the end of the hearing rather than at the beginning. So the way you rehabilitate the process to make sure it's fair to everybody, remember it's supposed to be an impartial hearing, is the chair would stop and say, I'm going to stop right there. We've had a disclosure. Does anybody wish to rebut or ask questions about any of the disclosure that the planning commissioner just made? And presumably people understand what that means. And if not, then you continue with the hearing. So 2 weeks later, at the continued hearing, they want to go back and reopen the prior hearing because now they've figured out they wanted to say something or ask some more questions. And the mayor said no. And what Lupa said was the mayor did the right thing the first time the opportunity was there. After the hearing was closed, they had their opportunity. They didn't take advantage of it. That's over. I think on top of page 3, the second paragraph, here the Council Menke disclosed the contact. There was additional discussion with other councilors. The mayor then asked if anybody wanted to rebut the contacts, and no one responded. Unlike a Horizon case, in this case, the mayor actually reopened the public hearing and asked a second time if anybody wanted to rebut the contacts. Again, no one requested to rebut and those substance. So it was adequate. Have to address a belated request. So I haven't had this happen as far as I know. It's been pretty rare here. The courts in Oregon are very well aware that people, who represent their city are supposed to represent their city. You want to be talking with people in the community. The only thing I ask of you is to remember when you're in a legislative role versus when you're in a quasi-judicial role. Legislative role, talk to everybody about whatever they want to talk about in terms of planning things. Application for a specific use, specific zoning, try not to discuss. Conflict of interest in this case, I think the allegation was, it was something about because she was involved in some financial planning that she wanted to curry favor with Habitat for Humanity. It's just so remote. It's sort of like saying anybody who has a business would be interested in meeting somebody else who might potentially be a client. I don't think that that's going to fly in our state. At least I hope it doesn't. It has to be direct. That person is a client already, for example. Then you may have a business relationship, then you may have a conflict of interest if that person is the applicant. And I think that's happened one or two times. Usually it's the disclosure that the planning commissioner has made is, I think, more remote than a current client, but that's okay. The other conflict of interest is, the person is your brother-in-law. The person is directly related to you, then there's no question. I have not seen a case that I can recall where LUBA found that there was bias and that bias somehow affected the vote to such an extent that the decision of the outcome in the case would have been different, and they sent it back or reversed it. Anyway, the rest of it is maybe some entertaining reading. And if I'd be happy to answer any questions about that.
Buddy, any questions? Okay.
I think I forgot to give you, and I might have intended to do it, I forgot to give you the definition from ORS 244 that actually states conflict of interest and potential conflict of interest. I know I've given it to you before, but I'll provide that before your next meeting. I want to make sure you have the definitions because that law has been changed in the last session. And I think it's actually been cleaned up, at least the gift provisions, which I don't think has been much of a concern for the Planning Commission, but I suppose it could be if somebody wanted you to offer you a gift because of your role, and you have to say, wait a minute, is this because of my legislative role or my Planning Commission role? Is this because I'm a Planning Commissioner that I'm getting this gift? If so, then the gift rules apply. Those rules have been changed to make it much clearer what's a gift. Tokens that I think are less than $25 are not even included in the definition. If you get a pen, if somebody wants to give you a plaque for speaking at something, at some kind of event, those are pretty much exempted from the definition of gift. If somebody wants to give you, $100 worth of tickets to an event, you can accept that gift, but that's your full limitation for the year. So you're limited to $100. Last time I looked. But I'd be happy to go over gift issues and again those state law definitions, and I completely forgot to provide them tonight. Sorry about that. But
Well, I've been here for 6.5 years, and it's never been an issue, so. Yeah, darn it, huh?
Yeah. Usually the gift limitations, I think that they actually have, City Council has had to deal with them more through travel and going to meetings with, the issue is, can I accept this meal? The meals got really complicated. Now I think it's been simplified. If you're having those meals together with other representatives, it's fine. You can't accept like a gift certificate to a restaurant. But if you're dining with the people who are interested in your have an administrative or legislative interest in the city, then that's something different. So I don't think those issues have come up often, but if you ever have a question about it, please give me a call. And that's really the extent of my rambling tonight. So
Good information. Does anyone? Thank you very much.
you're welcome.
Okay, next is reports and comments. Richard.
The only thing I want to mention is that next month the City Council, among other things, is having a workshop on affordable housing or workforce housing, and would be interested in hearing any input that the Commission might have on that subject, on things that might be useful to pursue or good ideas and that kind of thing.
When is their meeting?
Pardon me?
When is their workshop? Or
the workshop is March 14th.
Okay.
To 1:30 or 1 to 3. So we have a meeting before then, a planning commission meeting before then, but so you have time to think about it. But any ideas would be appreciated.
Okay. Thank you. Joan, anything else?
No.
Do you have anything? No, you don't. Okay. Planning commissioners? Again, we'd like to welcome Sean much. And nobody else has anything. Our next meeting is
March 6th.
March 6th. This time, this place. And I'm just going to remind Michelle that I won't be here.
Oh, boy.
Boy. Is there anything planned for the next meeting at this point?
No. More training.
More training. Okay. With that, if nobody else has anything else, the meeting's adjourned.